right, can I get us a convene here? Welcome students from both Dr. Henry's class and my class, and we've been planning this since last spring, and we're just delighted to have you here today. Thank you to Dave Rither from our ITS department for the filming, because this is part of a curricular package that the Council on Christian Colleges and Universities will be disseminating too. I'd also like to acknowledge that Dr. Lon from biology is sitting in, and we're really happy you're here. If you're in either of our classes, there's attendance sheets going around, so make sure that you sign those. Let me very briefly introduce our speakers, and we're going to start with Dr. Bretsen, and then Dr. Curry will speak, and then there'll be time at the end for your comments and questions. And I'm sorry that, you know what, after we start, I'll scout and see if we can steal any chairs from any of the other.
Look at this one.
No, you're going to need it. So, all right, just very briefly, this is sponsored by the Council on Christian Colleges and Universities, which offered a special grant for Christian schools to be looking at issues of the free market and public policy. And so this is the title of the grant proposal. Dr. Henry is the principal, what we call the principal investigator on the grant. I'm the sidekick. And we propose bringing in some distinguished speakers to talk to our students' combined classes about this. So from Wheaton College, Stephen Bretsen, in his article that I hope you've all been looking at on rainwater harvesting. Let's see what I will say exactly here.
As little as possible.
Okay. Yeah, this is more personal information about you, so I'm going to give this back to you. So let me just say that he's on the faculty at Wheaton College and is a nationally known expert on legal aspects of environmental issues. So we're just delighted, and he's going to be talking about his article that you've had access to. Professor Janel Curry is a geographer, and she and I have been colleagues for many, many years. She was on the faculty of Calvin as well as an administrator dealing with research, and since this summer has started serving as the provost at Gordon College in Massachusetts. And I have long admired her research on the environment and geography, and especially the issue of the role of the Christian faith in looking at environmental policy. Tonight, a third person is joining us, James Huffman, who's the emeritus head of the law school at Lewis and Clark, and then Professors Curry and Bretsen will be having some responses to his. I just posted on our Blackboard page his remarks, which I got yesterday. So us faculty, we don't do things at the last minute. So 6 p.m. Eaton Hall, room 112 is the second part of this program today. Okay, so all of you should be there. So without further ado, let me have Dr. Bretsen come up, and I meanwhile will scout out
Trying to get my PowerPoint up here. Close enough. All right, well, the irony is not lost on me that I've been invited to Seattle to talk about rain, having come from the Midwest where we experienced our worst drought in a long time. You're the experts actually on rain, not me, but be that as it may. Rainwater collection systems. All right, well, rainwater collection systems are a good thing, right? They represent a low-tech green technology, allow a local resource to be harvested locally if you're into the locavore movement, right? Rainwater harvesting is right up your alley. They're efficient, they lower the costs and the energy that's required to transport water over long distances. But rainwater harvesting is technically illegal. In many western states like Colorado, like Washington, because their water law is based on the prior appropriation doctrine. And the context for the prior appropriation doctrine is state ownership of water, as Colorado has done via constitutional declaration. In fact, Colorado goes even a step further with a statute relating to weather modification that claims the right to all moisture suspended in the atmosphere, which falls within its borders. And that moisture is encompassed within this constitutional declaration. And although the starting point is government ownership of water, private individuals and entities can obtain a private water right by diverting it for a beneficial use. Is anyone here from Chicago? No. Anyone familiar with the DIBS system in Chicago? Well, again, at least we have one picture. In Chicago, after a snowstorm, if you dig out a parking space, you have a right to that parking space. And I use the word right kind of loosely, to reserve that space for some indeterminate period of time. And the way you do it is with some random household object, like a lawn chair or something like that. That's your space. It's a good but imperfect analogy to the prior appropriation system. It's kind of the same with water. If you divert water, if you use it, you have the right to use that water for an indefinite period of time, subject to doctrines like abandonment and waste. And the property right's not an ownership interest in the water itself, but a right to use water, the right to capture a certain quantity of water at a certain place for a certain use based on a seniority system. And the seniority or the priority of use is based on the simple idea of first in time, first in right. So for example, in time of drought, the diversion works, right, the works that people use to move water out of a stream onto their fields, the diversion works of junior appropriators are shut down to satisfy the water rights of senior appropriators. So as a raindrop falls to the earth west of the 100th meridian, where the prior appropriation doctrine predominates, there's property rights on the ground waiting to make their claims on that raindrop, on the use of the water in that raindrop. And among those claimants, rainwater harvesters are likely to be junior appropriators who are capturing, using, and consuming water out of priority, which is what makes their activities illegal and upsetting to senior appropriators. And you can see the strong emotions associated with water involved in the strong language that's used here. I like the word dibs is in there. Coming from Chicago, the word dibs is actually in there. But there's other even stronger concepts like stealing water, like acting as a squatter. Well, the Colorado legislature addressed this problem by passing a statute in 2009, which allows rainwater harvesting under limited circumstances. I'll let you read that. But even with this legislation, an unauthorized rainwater harvesting system can still result in a $500 fine for each violation. So it kind of makes a rain barrel a little bit like a marijuana bong. Right? It's not per se illegal, but when you put something illegal in it and start to use it, well, that's when you can get into trouble. In Washington, and I'm not an expert on Washington at all, but since I was coming out here, I did some quick looking. In Washington, legislation authorizing rainwater harvesting had been introduced annually since 2002, but none of the bills became a law because of water law concerns. But finally, in 2009, the Department of Ecology, which has management responsibility for water resources in Washington, issued something called an interpretive policy statement, clarifying that a water right is not required for a small-scale rainwater harvesting system as long as the rainwater is stored and used on the parcel where the system is located. Now these actions, these state actions, create a potential for a taking and the need to pay just compensation, since the downstream senior appropriator is entitled to the prior use of the water if there's not enough water in the system to satisfy all the users, and they're entitled to the full amount of their water rights. Now I imagine at this point in the presentation you're saying to yourself, so what? Right? A little bit of rainwater captured in a rain barrel, it can't be a big deal, right? And if that's your reaction, I mean, I understand. The quantities of water involved are small. In a study of precipitation falling in northwest Douglas County, a growing suburban area in the foothills and plains just east of the Rocky Mountains between Denver and Colorado Springs, the average loss of water due to evaporation and plant transpiration on undeveloped sites was 97% of the total precipitation. So not much rainwater is getting into the water system anyway, at least at that location. Plus, we're just talking about small scale systems, but a parallel statute enacted at the same time by the Colorado legislature authorized a limited number of permits to establish development-wide rainwater harvesting systems in residential developments as a pilot program to explore those issues of evaporation, transpiration, return flows. Of course, since this is Colorado and the prior appropriation doctrine, the developer has to submit an augmentation plan to replace all the water that they capture. But what we see is the vision for rainwater harvesting in Colorado is potentially much larger. And even though the quantities of water involved, oops, my picture didn't show up. Even though the quantities of water involved are minimal, the principles involved are very important. The potential taking is the type that most disrupts the social contract, most upsets the average person. Right, a transfer of property rights from one private individual to another private individual with some sort of vague public purpose rationale. And just think of the reaction to the Kelo case a few years ago, in which the United States Supreme Court upheld the condemnation of private homes to make way for development that included a Pfizer research facility and a hotel based on a broad reading of what's a public purpose, right? Employment, tax revenues. Another important consequence is that if private property rights are not protected from a taking, the government actions allowing rainwater harvesting will redirect water to urban uses. And Lauren gave me a question about geography, and I think geography does play a role in rainwater harvesting, at least as a practical matter, or maybe a political matter. Now, I don't know whether the rules should be different in New Mexico and Arizona versus Washington, but it does seem that the more important rain is to recharging aquifers, to maintaining stream flows, actually the weaker the right to rainwater harvesting should be. But when I think about this area, like in Seattle, rainwater harvesting is less of an issue because what I understand is you get a lot of rain, and at least that's what I've heard, and you're at the mouth of the river, you're at the end of the pipeline. So most rainwater is going to go into Puget Sound if it's not captured. So rainwater harvesting is less controversial, at least in western Washington versus Colorado or perhaps eastern Washington. So as I said, 80% of the water out west is used for agricultural purposes. I get a partial picture there at least. Is used but with the political cloud of the cities combined with over-appropriated water systems, with climate change, that's all going to shift water from rural areas to urban areas. And rainwater harvesting just becomes one way of doing so. And while agricultural uses of water, tend to have lower values than urban uses of water, and the transfer of water from a low value use to a high value use, as economists will tell us, will produce gains, senior appropriators are not going to benefit from these gains. Right? The property rights that would have protected them, would have protected agricultural interests and their water rights, and have forced a payment of compensation by urban interests, either via just compensation for a takings or via market solution, are discounted and undermined. And this is not just about farmers. I mean, others concerned about rainwater harvesting in Colorado and Washington include Native Americans. It actually includes some environmentalists concerned about maintaining in-stream flows to protect fish and other wildlife. So the question that I'm left with is that, is rainwater harvesting ultimately possible without violating the property rights of senior appropriators and triggering a takings? And another way of exploring this issue is asking to what extent are water rights considered constitutionally protected property rights so they can't be taken without the payment of just compensation. And so as a result, my focus is on the takings clause of the United States Constitution and similar clauses under state constitutions, which do allow a government to take private property, but only for a public purpose and only with just compensation. The big question here is, do the senior downstream appropriators get that just compensation? Well, there are several ways, I think, to permit rainwater harvesting without violating the property rights of senior appropriators and triggering a taking clause. And I think the easiest and most honest way is to legalize rainwater harvesting in limited circumstances, which is what both Washington and Colorado have done. Washington's approach, I think, is appropriate. It's kind of laid back. Small-scale rainwater collection systems are allowed until someone complains, right? Until we get problems, right? We're just going to let it happen until we get problems. Colorado's approach is to work within the confines of the prior appropriation doctrine. The constitutional language giving the right to appropriate is limited to natural streams. And the current rainwater harvesting statute, a slide you've seen before, limits rainwater collection systems to residents with wells or well permits in designated groundwater basins. And generally, the presumption in Colorado is that all water is tributary to a natural stream. That's the presumption that has to be overcome if you want to, for example, engage in rainwater harvesting. However, in a designated groundwater basin, the presumption is the exact opposite. The burden of proving that water is not needed to fulfill surface water rights, or that it has more than a de minimis impact on surface stream flows, is on the person claiming an injury to their rights. So the presumption flips in a designated groundwater basin. Plus, the presence of a permit indicates that state authorities thought that there was unappropriated water that was available, and the well, and thus the rainwater collection system, aren't going to injure or impair anybody's water rights. So I think the downstream senior appropriator is going to have trouble overcoming the presumption that rainwater falling in a designated groundwater basin is essentially non-tributary water, which is just not part of their property right. Only tributary water, water in a natural stream, is part of their property right. And so I think they're going to be unable to show that the current statute, the rainwater harvesting statute, results in a taking. Of course, I bet this isn't going to show up. Oh, it did. Of course, what makes the Colorado rainwater harvesting statute, what saves it is what makes it so frustrating. Right? The designated groundwater basins are in the eastern part of the state, away from the heavily populated Front Range. Plus, the statute doesn't apply to residences that can be hooked up to a water system, like a municipal water system. And as I mentioned, the political pressure from the urban and suburban Front Range will require a larger vision of rainwater harvesting outside of these designated groundwater basins, which would presumably be water that's tributary to a natural stream. Another way to expand the scope and scale of rainwater harvesting is to rely on something called the public trust doctrine, the judicially created public trust doctrine, in which the state is deemed the trustee of a very broadly conceived public interest in water. The original values protected by the public trust relative to water were limited to things like unobstructed navigation, commerce, and fishing on navigable waters, but the doctrine's been expanded to non-navigable waters and to values like recreational values, ecological values, aesthetic values. And essentially the public trust doctrine is a dynamic one, right? And the nature and extent of what it protects is determined by the judiciary and judges' views on public policy. And under the public trust doctrine, a state is obligated to prevent anyone from acquiring a water right that's harmful to the public interest, such as a public interest in preserving endangered species. And that obligation is enforced by the court. So ultimately, the public trust defines the limits of private property rights. The theory is that all private water rights were granted subject to the right to regulate to protect the public trust. So when the regulations go into effect, they don't result in a taking. It wasn't part of the property right to begin with. But there are several problems with using the public trust, at least in this connection, and at least in the issue of rainwater harvesting. Except for California, Montana, the status of the public trust doctrine as a limitation on water rights is uncertain at best. Colorado has definitely not adopted the public trust doctrine. I mean, it's a very strict, very orthodox state when it comes to the application of the prior appropriation doctrine. And second, the change in water rights represented by rainwater harvesting is not to protect the environment, but is to transfer the right to use water from one private property to another, right? Hardly a public trust issue the way it might be, for example, with the Endangered Species Act. Of course, the most dishonest way of to circumvent the existing water rights of senior appropriators and to allow rainwater harvesting is simply to redefine property rights to exclude appropriative water rights. Right? Legal scholars who propose doing so look at the nature of water and have some good points to make. I mean, water is necessary for survival. Fresh water is a scarce resource. It's a dynamic resource that evaporates, can be reused, it moves. It's an uncertain resource because of droughts, floods, climate change. And as a result, these scholars believe it's hard to have a strong property right in water. And these scholars would also highlight the uncertain legal status of water rights in the prior appropriation, under the prior appropriation doctrine. It's limited by historic use, it can be forfeited or abandoned due to waste or non-use. And so instead of a full property right protected from a takings under the Fifth Amendment in which just compensation would be paid, it's a more limited property right, right? That's only protected by the 14th Amendment guarantee of procedural due process, right? It can be taken, but it can only be taken subject to a fair process, right? And just compensation then doesn't have to be paid. The problem with this approach, I think, is that at least in Colorado, that the state law, and property rights are a matter of state law clearly recognizes water rights as property rights, private property rights. And Colorado's not the only one. That's a pretty common way of looking at water rights under the prior appropriation doctrine. Now remember, the property right's not ownership to certain molecules of water, but it's a right to divert a specific quantity of water for a specific beneficial use with a specific priority relative to other users on the same water source. And the value of the property right is in its priority of use and the ability to enforce that priority during a drought from in an over-appropriated water source. And an appropriator who's been diverting water from a stream, putting it to beneficial use, such as agricultural irrigation, pursuant to decreed water right that, at least in Colorado, if it dates back to the late 19th, early 20th century, has a strong property interest in that right to use water. Well, given the desire and political pressure to expand rainwater harvesting, given the limited adoption of the public trust doctrine in Western states relative to water, given the strong private property rights in water under the prior appropriation doctrine, does rainwater harvesting result in a taking? To answer that question, we need to examine how the government has impaired that water right. And I don't think anyone would disagree that an outright condemnation of a water right and the transfer of title would result in a taking and the need to pay just compensation. But the rainwater harvesting scenario is not so clear-cut because it involves a government authorization, right, not an outright condemnation. And government authorizations and regulations are cheaper than condemnation, right, because they don't normally give rise to the obligation to pay just compensation. That's why governments like them. However, as a check, the Supreme Court has developed, and the Colorado Supreme Court has adopted 3 tests to determine when a regulation has gone too far. The first test that I want to talk about is the total regulatory takings analysis developed by Justice Scalia in the Lucas case that would find a per se or automatic taking if a regulation prohibits all economically beneficial use of land. So the first distinction the test makes is between real property, that is land, and personal property. The former is protected, the latter isn't. And the good news for the downstream senior appropriator claiming injury to a water right from rainwater harvesting is that in Colorado, the right to divert and use water is considered an interest in real property. The bad news for the senior appropriator is their difficulty in showing that the statute or regulation authorizing rainwater harvesting is a confiscatory regulation, that the loss of all economically beneficial use of their water right. I think the confiscation argument is difficult to make since the senior appropriator receives the benefit of the return flow from the rainwater harvester's activities, and the water right just continues to exist with its priority that can be enforced against anybody else except the rainwater harvester. The second test is a partial regulatory taking analysis developed by Justice Brennan in the Penn Central case, which involves a judicial balancing of multiple factors. And a downstream senior appropriator, I think, is also going to struggle to sustain a takings claim under this analysis. The first prong involves a very fact-specific inquiry into the economic impact of the regulation, and I think the de minimis quantity of water lost due to the rainwater harvester's activities are going to be relevant and weigh against the senior appropriator. A rainwater harvesting system for a typical family home with a 1,000 square foot roof results in about 600 gallons of water for every inch of rain. While the agricultural irrigator's water is measured in acre feet. Right? An acre foot is enough water to cover an acre of land 1 foot deep in water, about 325,000 gallons of water. And a typical farm in the arid or semi-arid west might use an average of 5 or 6 acre feet of water per acre, which means that a 160 acre farm uses close to 300 million gallons of water per year. So you can see, the disproportionate relationship between the two, I think, is obvious, at least until rainwater harvesting either becomes widespread or conducted on some kind of larger development-wide scale. In addition, the mostly non-consumptive authorized use of captured rainwater and these existing these evaporation rates, transpiration rates, are going to become relevant and weigh against the senior appropriator in the judicial balancing. And the Supreme Court has also made clear it's going to look at the property right as a whole, right? Not just one little aspect of it, like priority or something like that. And when we look at the senior appropriator's property right as a whole, they're still going to earn a reasonable return on their investment, right? They retain their priority again against all users except the rainwater harvester, and they can take advantage of other rights of ownership, selling their water right, leasing their water right, using it as collateral for a loan or something like that. The final test is the most promising one for senior appropriators, but also the most controversial one. In the Loretto case, the Supreme Court identified another type of per se taking that occurs with a permanent physical occupation of private property. Again, per se means automatic. So a taking occurs even if there's a minimal economic impact on the property owner. In the Loretto case, the impact was positive because the apartment buildings would now be cable ready at no cost to the landlord, yet there was a taking was found. So with a per se rule, the de minimis quantity of water affected by rainwater harvesting just becomes an issue for the amount of the compensation, not for the liability for a takings. And a trio of Supreme Court cases from the mid-20th century recognized that a physical diversion of water affecting existing water rights constituted a per se taking. Two of those cases involved a dam that interfered with the natural flow of the river, and thus the water rights of the downstream agricultural irrigators. And since attorneys rely on analogical reasoning in making their legal arguments, I hope you can see that the relationship between the physical diversion of water created by a dam and the physical diversion of water created by a rainwater collection system. The scale might be different, it is different, but again, with a per se rule, the scale is only relevant to damages, not to liability. More recently, lower federal courts have found physical per se takings when the Bureau of Reclamation required an agricultural irrigator to construct a fish ladder at their diversion dam and divert water that would have gone to their fields down the ladder to protect endangered trout. and also when the California Water Department reduced water deliveries to agricultural irrigators to maintain stream flows for migrating salmon. Again, the rationale relates to the nature of water rights. The chief value of the water right is its priority and the right to use a certain amount of water. If the priority is taken, the water right is taken. Plus, for a water source that's already over-appropriated, the right of use can be affected. Thus, a change in either priority or use represents a transfer of value from the downstream senior appropriator to the rainwater harvester. Their right of use is diminished, the rainwater harvester's right of use is increased, and that's the functional equivalent of a taking. In a more recent case, involving temporary restrictions on real estate developments on Lake Tahoe, the Supreme Court carefully distinguished physical occupations from regulatory takings and said that permanent physical occupations are rare, they're easily identified, and the per se rule only applies to them. But I think even with the Tahoe Sierra case, the logic of applying per se rule to rainwater harvesting and is stronger than not doing so, perhaps as opposed to something like the Endangered Species Act. Again, rainwater harvesting represents a physical interference or diversion of water authorized by the government, so the physical appropriation due to the regulation is obvious. The Tahoe Sierra case involved a temporary 32-month moratorium on development, while rainwater harvesting is not temporary. Right? The statutory right to capture rainwater is likely to continue indefinitely. In fact, one aspect of the Washington Department of Ecology's interpretive policy statement on rainwater harvesting I think is quite clever, is to make it sound temporary. Right? We're going to allow rainwater harvesting to continue unless it causes problems or complaints. So it sounds temporary. So while it might seem that the physical per se test would turn rainwater harvesting into a taking, the downstream appropriator has one more hurdle to cross. A senior water right is not protected from any injury, but only a material injury. And at least, and that's the standard in Colorado. It's pretty common in all prior appropriation states. Thus, a water right affected by a physical taking has to be materially injured to first qualify as a property right protected by the per se taking rule, if that makes sense, right? Only a property right is protected by this per se taking rule, but the only property right that's protected is against material injury, not just any injury. And as you can see, the inquiry into a material injury is highly fact-specific. It involves experts like hydrologists and water engineers. And because it involves those kind of people, it's expensive, right? So the burden of proof matters, right? Who has the burden of proving material injury, right? Just like in criminal law, right? The burden of proof matters, right? We know that in criminal law, the burden of proof is beyond a reasonable doubt, right? We've all seen the movies and the TV shows, right? And that burden of proof matters, that is on the state. And so burdens of proof matter. Well, consistent with other areas of the Colorado water law that place the ultimate burden of proof on the person initiating a change to water rights, like if you want a new water right, the burden of establishing no material injuries on you as the junior appropriator. If you're a senior appropriator wanting to transfer your water right, and anyone transferring their water rights is probably a senior appropriator because they're the only ones who have old priority dates that have any value. If you want to transfer that, you're the one who has the burden of proving no material injury on the junior appropriators. So consistent with the idea that the party initiating the change in the water right should have the burden of proof, I think the burden of proof should be on the state government or the rainwater harvester, but at this point that's unclear. But if development-wide rainwater harvesting, these pilot programs that I mentioned, confirm that net depletions due to evaporation and plant transpiration on undeveloped sites only averages 3%, then perhaps the state government and the rainwater harvester have the evidence they need to show no material injury, of course, and thus no taking. Of course, 3% of a big number can be a big number, though. Plus, in one of those recent lower federal court cases I mentioned, the fact that the water restrictions resulted in an overall reduction of water of less than 3% didn't prevent a ruling in favor of the senior appropriators. And of course, even if the senior appropriator can get over this material injury hurdle, they have to establish and they're able to show this physical per se taking, they still have to establish the amount of the just compensation, fair and reasonable value of the property taken, which is no small task. The burden's on them, again, requiring either all that expensive expert witness work, or perhaps, again, relying on that pilot program information. I think either way, whether through a material injury analysis or a just compensation analysis, I think this idea of net depletions, right, currently a 3% figure that's out there, will be key in developing some kind of solution to heading off a potential fight between rainwater harvesters and downstream senior appropriators, likely a market solution. And to answer Sam's question about net depletions, I like the idea of net depletions. It makes sense. It seems to be a way to reconcile the interests of the parties. I'm not ready to embrace it, though. Maybe give it a little man hug or something like that. But I'm not ready to embrace it. Because one problem is that net depletion assumes that the rainwater collection is happening on a parcel in its natural undeveloped state. But if rainwater harvesting becomes more widespread, it's going to involve the suburban and urban areas where water that's not caught goes down a downspout, goes down a driveway, goes down a street, goes down a gutter, into a storm sewer, and into the stream system. And I think in that case, a lot more than 3% is probably lost by the downstream senior appropriator. And to answer Davis's and James' questions, water markets do exist out west. They're not perfect markets. They're not always efficient because a lot of people and entities have a veto right over water transfers. And of course, with markets and private property and the whole historical development of the prior appropriation doctrine, there's never going to be equal rights to water. And to answer Malia's question about public versus private, obviously you can tell I lean towards the private sector. I think strong private property rights in water allow the market to work and allocate the water to uses that have the highest value, but the prior appropriation doctrine is imperfect. It encourages overuse of water, right? It's a use it or lose it system. If you don't use your water, you lose it. It goes to somebody else. So it encourages overuse. If you do things to make the delivery of water to your fields more efficient, if you line your ditches and use pipes instead of open ditches and stuff like that, you don't get the benefit of the extra water. That goes to somebody else. So there's a lot of inefficiencies in that system. And so I think there's definitely a public role there. And to answer Ryan's question about acid rain, well, that's a bigger problem, I think, for water quality than just rainwater harvesting. I don't know that much about elevated pH levels. My last chemistry class was in high school, and I know that you balance out acids with bases, but I'm probably off base in even saying that. And then finally, I had a question from Aaron about this issue of utilities. I don't think there's enough rainwater out there, or at least ways to capture it so that people can, on a widespread basis, so that we can sort of not be reliant on a central public utility. But I do think that rainwater harvesting can relieve some of the capacity constraints that are on public utilities. So I think I'm true to my half hour. And I'll just put this plug in. If you think these issues about water law out west are strange or obscure, I brought this in. This is from early October of this year's Wall Street Journal. Parched in the West, but shipping water to China bale by bale. And the water that's being shipped is obviously in the products that are grown out west. And the article is all about some of these issues of water rights created by the prior appropriation system. So it's out there and relevant, even if it seems kind of obscure. Thanks.
And I'm going to get you to think a little bit theologically and about what Dr. Bretsen has been talking about. So to begin with, I want you to think about the law as, in a way, defining relationships between individuals, the community, and nature. So think of this relationship. And I would say that not only the law helps define those relationships, but also policy. Public policy helps define these relationships. So when we're talking about water in the West, we're talking about who has the rights, an individual, or does the community hold those rights? And then, of course, there's the issue of nature and the different kinds of ecological systems in which the law is shaped. Okay, so that's sort of a larger picture. To begin with, what I want you to do is take out a blank sheet of paper, and for each of you, you have 1 minute to do a diagram that shows the relationship amongst God, humans, and nature. Just do a quick diagram of how these relate to each other. So a schematic of your way of thinking of how these three relate to each other.
Do you want more board space?
No, this is already. And I won't grade you on your ability to draw. Okay, you have about 15 more seconds. Now, quickly turn to somebody next to you and show each other your diagrams. And look at how are they the same and how are they different?
Triangle.
Okay, now tell me what were some of the differences between amongst your diagrams? Anybody? What were some differences in the relationships and how you saw them? Yeah.
Both of us put God first, of course, but she puts humans and nature on the same level, and I put nature and then humans.
Okay. I can spell humans. Nature. So either the same level or different levels. Okay, so whether you see a hierarchy, God, humans, nature, or humans and nature at the same level. So any other differences you saw amongst your diagrams? Was that the main one?
Some of us did the triangle representation again, and then others did the Venn diagram of God being the bigger circle, and then humans and nature is entwined in the middle.
So some had this is God, and then this is
Then it would be two same size circles interweaving of human and nature, saying they're separate things but parts are intertwined, like that, and God encompasses.
Okay, so sort of where God is in the midst of that. Any other interesting differences? Okay.
With mine, I struggled with whether to put humans and nature on the equal level, sort of inside a circle, and then I didn't want to put God inside the circle. It seemed like it constrained God. I didn't want to put him outside the circle because it seemed like it removed him from humans and nature. So God was sort of half in and half out of the circle.
It's really, and I actually think it's very difficult in English to even verbally describe this because our word nature excludes humans, so that there's no word to even visually put them together as a whole. So theologically and English-wise, it's a problem. Any other struggles that you had in conceiving this or differences? Yeah.
Well, one of the things that I thought of in terms of the relationship was also the word responsibility, in terms of like how to assign priority if we're talking about hierarchy, or like in Venn diagram form, you know, like how that would translate.
Okay, and so trying to define not only where they were in relationship to each other, but almost obligations between, amongst them. Anything else? Okay, we'll come back to all this in a few minutes. Okay. What I want to do is just summarize some points which I think came out in the article that you read. One is that God cares about the earth. So theologically, when you look at law and water and everything, it's not just a commodity. God actually cares about the earth. And I think you saw in the issue of eschatology, there are different theological positions on what that means. And some think that God cares about the earth because of what it does for humans. Other theological traditions think God cares about the earth because this is the actual earth we'll be on when Christ returns. So there are different theological ways of emphasizing that. And another theological statement I'll make that has differences amongst different Christian communities is that we are made for this earth. Some think we're made for heaven. Some theological traditions think we're made for this physical earth. So again, that has to do with the continuity. And maybe that the differences in theological traditions then impact how you see this relationship between humans and nature. If you think we're made for heaven and the earth doesn't continue on after Christ returns, then you have a different view on this, because maybe it's more humans and then nature that's underneath. So your theological viewpoint shapes how you start to build a worldview of your relationships. Okay? I believe that wisdom is about knowing how to manage the relationship between humans and nature that honors God and leads to flourishing, or God's intention for all of us. And in that sense, law and policy is about different ways of managing those relationships. So I think one person asked, is this then, should Christians be involved in this, or should there be a separation between church and state? I think it's about not a separation, but that it's your value system and your understanding what God wishes for community and nature that shapes the kinds of policies that you then enact. So here are just a few principles that I think about when I'm thinking about policy. One is humility, that only God knows everything. And so when I think about policy construction, you think about the unknown. And there's a principle called the precautionary principle. Are we constructing a policy that shapes our relationship that takes into account we just don't know everything? So you have to be cautious in your approach. And I think when you talk about water rights, this is part of it, is the hesitancy of always going down the route of private property is that once you establish that right, it's very hard to go backwards from it. So it's a precautionary position to make sure you do it in a way that in the long run allows you to be flexible when you learn more. Okay? Another one is policy that somehow recognizes the whole of an ecological system, not just the pieces. And I'll talk about some research I did in New Zealand around marine policy and fisheries. They put into place a privatized fisheries system so that individuals were given quotas for a certain number of, or it must be tons of particular species. And in a way, this was a good way of doing it because there had been overfishing, and it would reduce overfishing because you couldn't get more than your assigned tonnage of fish. But the problem is, not all species have value in the system. So that the policy doesn't incorporate the value of the ecosystem as a whole. Each of these species is in relationship with other species. And so somehow policy has to be structured so it thinks about the whole. And we see this in water policy, and that for a long time we didn't understand that water in the stream was important for ecological processes. It wasn't just water that you remove and take someplace else. So we had to rethink our understanding of water and restructure our rights to actually recognize in-stream rights. The rights because of the fish that needed it to keep flowing. Okay, so the whole, thinking about the whole. And then I would say that policy and the establishment of property rights have to move towards the direction of care. So it's towards shalom and wholeness. So the measure is not whether you think it should be private property or some other form, but is it moving you in the direction of shalom or wholeness? So humility, thinking about the whole, care, and then the last one I would say is community. Does it strengthen community and relationships? There's what's called Trinitarian theology that says that being made in the image of God means we are made to be in relationship, just like the Trinity. God is a relationship, in relationship with himself. So that would say that we are made for a relationship to nature, to each other. And so in order to have shalom or that kind of flourishing, then you need policies that are leading to more and richer relationships rather than diminishing the relationships. So that would be the fourth, sort of standard or the way I think about the construction of policy. Now, you notice some of the things that come from this is first, every context is different. So where private property could lead to all of these things in one context, it might not do that in another context. So understanding the individual situation is important. And so it's not about an ideological position of either government or property rights, which I think in the United States we're often forced into these two categories, but rather what works in this context. What works in this context? What gets us to those principles of shalom? And what reinforces or enriches our relationships? And what kind of approach is precautionary so that we know we can adjust in the future as we learn more about the situation? So that's sort of my principles, and now I want you to go back here and think about this. How would the diagram that you drew, how does it reflect or how would it influence your policy perspective? So I'm going to put the typical one: God, nature, humans. And I'll show you another one that I often see versus. You didn't want to put God in the middle, but I'm going to put God in the middle
There you go.
in a way. Where I say God throughout, right? Sustaining. And then humans and nature.
I don't have enough time to do that.
Yeah, exactly. Just look at these two, and how would your policy or your perspective be different if you had one worldview or the other? Maybe I'll even ask you, what do you think?
In terms of water law or just in general?
Well, even water law would be an interesting one.
and explain the second diagram again, make sure I
It's
understand.
more,
There's a lot of lines there.
God is throughout.
Okay.
So
okay.
sustaining the processes and.
Right. Well, I think, I mean, in one, you're looking at I think more of a, on the right, I mean, you start thinking about more of a community focus, you think about more, to me, more of a collaborative focus, and the one on the left is more of a sort of a top-down, kind of authoritarian, you look at things in...
This should have been turned around, sorry. Yeah.
You know, in terms of, you know, sort of authoritarian, top-down, imposing things.
Yeah. So where you're talking there is even the process of making policy might be very different in these two. Any other thoughts on how you might approach it or what kinds of options you might include in what you're thinking about as you shape policy?
Well, I just had a question. So in like, let's say just even a local level, you know, policymakers have to please lots of different people with lots of different views on these things. How would using your 4 kind of qualifiers, how would you propose that someone do that when there's not everyone's on the same page with everything?
Yeah, no, that's a great question because I think often it's more this way in that then at the human level, okay, everybody comes to a commission meeting, they all give their opinions, and then a decision is made, and then you impose it. Okay, we consulted with the public. That's it. I think with maybe this model, there are some alternatives where it's much more the community tentatively decides a direction, so out of discussions, and then they go, and I always talk about this as walking the watershed, right? And then they monitor it. And they say, okay, is it taking us where we want to go? And then they make adjustments. And so it's much less just, and it's also involving nature in that you're going out and you're looking at your relationship with, ongoing relationship with that ecological system along the way, rather than making the decision and then it's done. So does that help?
Yeah, I guess I just have a hard time seeing the second model. You know, to me it like makes sense if you're talking about a very small community, but on a larger scale it seems a little more impossible.
And I think what you have to think is if you make national policy with this worldview, this is not the way policy, with this worldview, you might have a more emphasis on the concept of subsidiarity, where you push the decision-making down to the lowest appropriate level. So it would be the principles out of which you build your policy that might be different. It might emphasize more local control than national control. It might look more at context for the local decisions. Yeah.
I'll be unashamedly showing my ignorance here for you and Professor Bretsen and Professor Henry about the law. But how does such a dynamic, interwoven community process work? Where, as I understand it, with the law regime, precedent is so important, and yet the context for all those precedents in terms of laws that deal with an ecological system are going to change so much. I guess I don't understand how to see the dynamism required in what you're suggesting, and yet respect for the precedents set in the legal regime.
Well, I do think, I mean, you know, you had mentioned that Professor Huffman's going to be talking about his comprehensive river basin management. I mean, and clearly he shows, his thesis there is that it's difficult to make that work as you bring more and more people into the process and you give everybody some kind of right, you know, a voting right or something like that. And so I do think the process is going to be more complicated than simply having everybody at the table and everybody having an equal voice, because that doesn't necessarily represent what everybody's bringing to the table in terms of property rights and things like that. But I do want to emphasize the point, you know, as you said, sort of these precedents in the past. I mean, this water law we have, this prior appropriation doctrine, I mean, is, I don't want to call it a relic, but it is a system of water rights that was put together, back in the day, right, back in the late 19th century. And at that time, the emphasis on kind of all natural resource law in the United States was on extracting and using the resource. So if you think of just something as basic as the Homestead Act, which we all kind of know, right? The idea was to get people out west and get them using the resource, farming that 160 acres. Same thing with the Hard Rock Mining Act, stock, all those, including this water law, was to use the resource. And now we want to view the resource differently, as you mentioned, like the importance of in-stream flows. I mean, we all understand that now. We didn't understand that then. Yet we have this property rights regime, as you said, you have to be careful. And of course, we weren't thinking about those things. The policy was to settle people in the West and use it. And so what we have is a legacy of that. But at the same time, property rights were created, promises were made. And so you can't just sort of get rid of those with a sort of collaborative process. And so I think that process is a very dynamic one where everybody comes to the table, but not everyone necessarily has an equal vote.
So, Chair, in response to that, why don't you go first?
I was saying, one other thing to notice that in many ways rainwater is sort of the ideal scenario for using more of a market-based system. It gets trickier the more easily things transcend geographical boundaries. And so, for example, pollution, some forms of pollution that easily transcend state boundaries can get much trickier than rainwater, which can be a little more localized in this way.
Just read one of my favorite quotes. It's about law can very often be seen as the making of judgments coupled with the attempt to determine how far we can live with the judgments we have made in the past. So in a way, law is always reflecting what we understood in the past. And so change is dynamic in that you're always moving in a new direction as you understand more. And so I think the important thing to remember then is it's never finished. Policy is never finished. It's just what we know now, and then you have to move forward.
And law is always going to be a laggard.
Yeah.
Law is always going to be a laggard.
So you're always living with your understanding of the past and trying to push it forward. Okay. I think now it's time for questions.
And any of you from my class who want to be really brave, because you just did a report on non-Christian theology, would you see the diagram any differently? Some of you studied Buddhism, Islam, Confucianism, I don't know. If you were thinking about that when Professor Curry showed the diagram. And Professor Henry's comment, this is tough enough for us at the national level, ramp it up to international law and
right, that's right. So there are different traditions of law, and then they have to interact. I'll show you one that a Buddhist drew for me once with the same question. It was just like this.
Because of the view of time.
I guess.
The sort of circular nature of time, constantly circling back and then going forward and circling back.
And another one was just that. Right. This is the Maori in New Zealand. Just a circle. Questions for both of us?
Yeah, I guess I should say. And I'd be interested in what you think of rainwater harvesting and all these complications.
Which we do all over the place in Seattle, by the way.
But only since 2009 could you do it legally.
And in Michigan, we do it in order to keep the water on site to percolate down into the groundwater, to keep it from running off and polluting the streams.
And from the Midwest to the East, you have a different water rights system, a riparian system, which would allow that. So this isn't an issue except out west. Yeah.
I don't know like much about law, but I feel like the prior appropriation laws, I feel like it's being held on to for too long. Like, is it realistic that like 50 years from now that it's still going to hold?
I think the law itself will hold. I think what will change 50 years from now is that water rights, like in a state like Colorado, where 80% of the water is used for agriculture. In many ways, we think of a place like Colorado or the West as not having enough water, for development and for urban and suburban uses. Actually, there is a lot of water out there that's been developed, but it's being used for agriculture, which, as I mentioned, consumes a lot of water, right? That 300 million gallons for a relatively small farm. So I think the prior appropriation doctrine, I don't think will change. Those property rights have been created. I mean, I talked about here about how they could change, but I don't think they would or should, because I think the people who own those property rights have been relying on them. That's their sort of their cash cow, right? If you're a farmer, your cash cow is you think it's your land, but out west it's the water that goes on your land, because water is more valuable than the land it goes on. If you don't have any water to put on the land, the land is worthless. So I think what will change in 50 years is that water will shift from agricultural uses to more urban and suburban uses. And the big question will be, will the urban people have to pay for that, or will they get it for free? And I think that's the big question that I'm trying to explore. And then rainwater harvesting is a way of exploring that. It's a little way, right, of moving a little bit of water to urban areas. But the question is, will they get it for free?
So yeah, how do you all feel about that in the West? Should the farmers be paid for the water that goes to the city to water lawns and
drinking water,
drinking water, everything that you use in an urban setting, or should that be something that the government just says that has higher priority than agriculture? What do you think?
We're very comfortable with silence, right?
Yeah,
It seems to me that if there's less water for agriculture, there'll be less agricultural production, which means there's less food for people to consume, so there'll be less people in general.
Right. Yeah.
Although, and in Washington State, we apples and berries, and we love them. But at the same time, I can probably go down to Fred Meyer and get some apples from not here. So
from Chile.
Exactly. And so that's the thing is like, yes, and I'm not saying I'm advocating for this, but politically, we hold on to our farmers because we don't want to tick off the farmers, right? But that's kind of, it feels like it's a dying industry in our agriculturally in our state, and whether that's a good thing or a bad thing, I don't think it's a great thing. But people are moving towards cities, and so the question is, and I guess I'm not really answering my question, but it's like,
we do it all the time as professors. We just raise questions and don't answer.
Yeah.
Perfectly acceptable in academic settings.
I should get a PhD.
JD is a lot quicker.
So basically, I mean, I guess the question is, do we care? Because maybe our industry is dying
If you want to
anyways.
get a reaction out of them, ask them how they feel about shipping Columbia River water down for use in Los Angeles.
Yeah.
How many of you think that's a good idea? Raise your hand. That we should create an infrastructure to sell Columbia River water down to those hungry Los Angelinos.
And the answer is every one of you from California or from LA needs to raise your hand.
And everybody from Washington needs to put.
That's right. Hit the people that are raising their hands.
Another complication in all of these choices is often it was a government subsidy that created the water projects, that gave the water to the farmers
Absolutely.
at a cost below
Absolutely.
the real cost. So then you go, well, is it that we haven't used the markets in the right way for water too? It's even more complicated. So my brother in Phoenix gets cheaper water than I do.
Right.
Because
Right.
of 100 years ago,
Right.
a decision that was made.
I mean, just like we subsidize truckers with the interstate system, we subsidize farmers with a system of diversion works, right? Dams and diversion works and pipelines and canals that move water all over the place.
And your electricity is subsidized that way in the Pacific Northwest at the cost of the salmon. So everybody, I always say everybody lives on the dole, just different doles.
And when I say agricultural irrigators, you got to realize I'm talking everything from family farmers to big agribusinesses, right? It's not all like some little, the Waltons or Little House on the Prairie kind of people, right? It's the whole range of people out there.
And then is it a national security issue to keep the capacity to grow the apples here? No.
I'm just going off what Dr. Braden said. Because I know water, I'm from California also, I'm from Northern California, and I know that water is a big problem, and they've proposed different things again and again to try to take water from the Sacramento Delta to distribute it to Los Angeles, the Columbia River in Washington, and down to Los Angeles. What do you guys think would be a good solution for an alternative? Because 75% of the population in California is in southern, while 75% of the water is in northern. So in a situation like that, would it be better to put some kind of like tax on people in Southern California to encourage them to move? Or do you think like, or what would you propose? Because I know it depletes the Colorado River, it's still a problem. What would you propose a solution for that?
I mean, I would like to see in those cases water reflect the true market value.
Right, that's what I would say the same thing.
Yeah, because in a way people are there because it hasn't.
Right. You can move there because it's, you can get what you need, the water and everything else. So I would agree. I mean, if we use the market, water would become more expensive in those places, and the use of it would decrease. Right. Same thing with gasoline. I mean, the price of gasoline goes up. We all start figuring out ways to use less of it, and so I think that would be my first response.
Well, and I think tying to what I said earlier was higher price for water makes people more attentive to the actual natural environment around them in Southern California, because right now what they have is an artificial environment. It's not the real environment.
There's all sorts of hands up over here.
That's what I was going to talk about. Is we in Southern California, we want the heat 355 days a year, but we also want beautiful green lawns. And so we need to come to terms with the fact that we live in a desert, and trying to make it the Northwest is never going to work.
But again, the big use of water is going to be agriculture. I mean, watering. I mean, watering a lawn is highly symbolic, and I think people should be asked to cut back on that. So, that idea of we're all in this together. I mean, sort of that model. But the big thing is, growing almond trees in the desert.
So, with the market-based solution to water, I mean, in theory, this is a great idea. Given back to your question about what are good policies and incorporating the whole, what are some strategies for assessing market value of water when it's not just necessarily opportunity cost, but also the ecosystem value of having? I mean, it's a similar question we have for what's the proper price for carbon, right? So what are some strategies for assessing the market value for water?
It's hard because what you're asking is how do you assess the market value of an ecosystem, right? And I think that's where we don't really know how to do that. Carbon's almost easier. Oh yeah, a lot easier than that because it's one piece and the relationships. I'm not sure that we...
Yeah, I think with water, I mean, I think generally when you're talking about in-stream flows, generally when you talk about in-stream flows, that's something a government wants, right, because of the Endangered Species Act or something like that. And I think if you made the government pay for the water to do that, then all of a sudden we would understand get an idea at least of the true cost of that. And I think the problem is we as a society have gotten used to getting benefits, right, from government, and we think of these entitlements is in the news, but we get these benefits from the government, yet we don't pay for them now, right? We defer the payment through borrowing. And so I think we've gotten spoiled in a sense of getting what we want without having to pay for it, and that's just simply not sustainable. I mean, it's not sustainable in terms of budget deficits. I don't think it's sustainable in terms of the use of water.
We have time for about one more question. Anybody? I have one that's, if the students don't, as I'm trying to see your wonderful presentations and writings from their viewpoint, and I find myself thinking, we keep telling them, as professors do, this is very complicated. Water is such a complicated resource, I agree. Can you think of a resource in which the market does do a good job allocating the use of the resource? What would be the opposite of the water case that you think, or is it that when it comes to resources and ecological relationships, et cetera, there's just no resource that the market can really.
And you're thinking about natural resources,
Yeah.
right? Not just
That would be hard. I mean, there are some that are probably better than water in that they stay put.
Yeah, they don't move, yeah.
Right, they stay put, but in some ways I think the pollution credits,
Yeah.
the market for pollution is, I think, more effective than command and control. And that's something that moves.
Yeah, I mean, sounds odd, but I mean, and I'm really a water guy, so I'm really starting to get out of my element. But I think about wildlife.
Yeah, that's
You know,
good.
and you know, believe it or not, there's a market for wildlife,
Yeah.
right? Hunters pay for the privilege of shooting Bambi, and they pay good money for that. Other hunters pay good money now for the privilege in Wisconsin of shooting wolves. And so, you know, and so when I look at that, I see wildlife making a rebound. And I see that resource definitely being managed by the state. I don't think perfectly, because it tends to manage it for deer, because deer is what brings in the money.
And it's a state permit
Yeah,
for not one particular deer,
Right,
but
right.
a deer.
right.
And do you think that that's really a market value to that permit?
Yeah, I mean, there can be, I think, and maybe less so now, but then that's so much easier in water because it's not like you had a right granted to kill deer, you know, back in 1890.
And you still hold it.
It's sort of renewed every year, and you pay for it. So I think it's imperfect, but I think wildlife gets a little bit closer to what we're talking about.
That's a good example.
Just to build on, I'm a wildlife ecologist.
There we go, finally. I'm way out of my element here.
I study deer. So, but I think, and we are moving towards that in wildlife management. We've really moved from a species-based species-based management to an ecosystem management. How can we use hunters as a tool to manage the ecosystem? And this is incorporated into the price of licenses, and it helps that they're stable and they're localized. And where it gets complex is when we're talking about migratory species like birds, and then you get to the same problem as you have with water that cross political boundaries. So it's moving in that direction.
Well, and I was thinking of minerals, but there you don't always have the externalities included in the cost too,
Right,
you know,
right.
in terms of the environmental costs of mining.
Right.
And
And clearly not with the hard rock mining. I mean,
Yeah,
that's just
yeah.
dirt cheap.
It sounds like a wonderful final exam question.
Yeah.
You guys can figure it out.
So if I get an email in a month or two, then I know it's a take-home exam question.
Can you all join Professor Henry and me in thanking